Florida real estate contract deficiencies? Nah, they don't exist. Maybe they do. I'll be right back. I've got more to share. Hi, everyone. Welcome back to another episode of Inside the Deal Through Michael's Eyes, where we work to bring you a fresh take on real estate and business in general. My name is Michael Rennick, and I am your host for this podcast. I combined a 31-year career working for General Motors, retiring at the young age of 52, and my real estate business. I've been a licensed agent or broker for almost 15 years down here in Florida. So the podcast is designed to combine both of those, but it's also designed to pull back the covers, to look at how business should be done right. There's a lot of things out there I think are wrong, and we want to highlight those kind of things. And I like to bring in the experts. So joining us right now for this episode, and many of you already know him, but this is Michael Hankin. And I'm going to do the short introduction because he knows where I live. This is the man I call a powerhouse of legal insight right here in Sarasota, with a deep understanding of the legal landscape and a commitment to helping others navigate complex issues. Michael brings a wealth of knowledge and a fresh perspective to our discussion. You won't want to miss this conversation. Hey, Michael, how are you?
Good morning, Mike. I'm doing great. How about you?
Doing well. Now, there was a lot of commas in that introduction, but only 3 sentences. You said 2. I gave you 3, but that second sentence was a pretty compound sentence. How about that?
It's getting shorter. I like it.
So you've got so many things that we could talk about with your background. I really appreciate all that you do and the help you bring the community. And, of course, your legal knowledge is second to none. Well, it may not be second to none. Your wife may argue that point. I'm not sure. But between the two of you, the 2 top legal experts in Florida, would you agree with that?
I know better than to argue with my wife, Mike.
So I started out by saying contract deficiencies. Nah. What's going on here?
There are so many. The standard contract that's used in Florida is or I should say the most often used form in Florida is called the FAR contract. And it's put together by a state committee consisting half of realtors and half of attorneys.
Well, that explains everything right there.
And the two work together to really try to come up with a fair and balanced agreement. It's not supposed to be buyer friendly. It's not supposed to be seller friendly, but they have this extremely difficult task of coming up with one contract that can be standardized and used throughout the state for residential transactions. It sounds great in theory, right? You can go anywhere in the state, have the same form, and we have a rough, similar way that things happen. But one contract form can't encompass all of the intricacies of any particular deal.
How about something simple? Seller agrees, buyer agrees, they match, sign here.
I'll buy it from you on this date at this time for this much. Strangely enough, the minimum legal requirement for a contract for real estate is an identification of the property and an agreement to buy and sell. So I'll buy your house at 123 Main Street is all legally is required, and of course signatures by.
So let me use my background here and interject. I can provide right now for you a legal quitclaim deed for that property. How much are you willing to pay?
I'd maybe want some title insurance and make sure you own it.
No, come on. See, you're making it complex. Now, for those that are listening or watching, my understanding of a quitclaim deed, all it says is I promise to convey to the other party any property any part of that I may own, right? So if I own nothing, it's still a legal transaction. Is that correct, Mr. Hankin?
Right. I give you my interest in this property, which may be something, it may be nothing. There's almost never a good reason to use a quitclaim deed.
That would be another good topic for a podcast down the road. How about that?
Be happy to talk about it. You know me, I love hearing myself talk.
I know enough about all these things to make a total fool of myself. So let's get back to the regular FAR contract.
Sure. So here, the most recent change in the contract, which has been causing a lot of issue, is who pays for the costs of closing services. So the change went into effect December 31st of last year. And it now says in the contract that the buyer pays for buyer's closing services, the seller pays for seller's closing services, and it has a rough definition of what a closing service is.
So let me jump in here. When I hear an attorney say a rough definition, go ahead, dig the attorneys out of this hole.
So the the definition in the contract for closing services references a statute. Statute has a couple of examples of what a closing service is, and it's things like preparing closing documents, dispersing money, coordinating the signing. But the contract, it really does an awful job and doesn't do any job of telling you what a quote buyer's closing service is or what a seller's closing service is.
And let me jump in for a second. Generally, in a negotiation, we negotiated one side or the other pays for the closing services. That's the way it's been in the past. I've seen it split once in a while, but generally you would say the buyer would pay it, the seller, and they would pay all the costs. This is now saying something different, correct?
Exactly. So before December 31st, the person who chose who paid for the title insurance got to pick who provided all of the closing services and would pay for those closing services. And that led to, I believe, a recognizable normal state of affairs, right? You would expect to pay somebody that you get to pick to provide services to you, even if some of those services benefit the seller in the transaction, or if you're the seller, they benefit the buyer in the transaction. You'd have the benefit of shopping around and saying, hey, I would like you to maybe handle my closing. How much is that going to cost? And if you don't like it, you could go to the next person. But with this new change, if you leave the contract as is, and let's say you're the seller, the buyer's paying for the title insurance, so they're most likely picking the person who's going to act as the closing agent and do all of those closing services. Now, that person gets to decide what services are sellers' closing services, what services are buyers' closing services, and then charge the seller, a person who didn't pick to use their services, but almost got those services forced upon them, whatever they want. So who knows how much that bill is going to be? This person who's providing the services has no allegiance to the seller who they're charging for those services. And we've seen all of these horror stories in just the last month and a half when this has been in effect, with people charging outlandish fees for services to somebody who never chose to retain their service. And now the contract does say you can pick your own provider of closing services, but without a definition of what a closing service is, it's hard to know what that is. Also, the cost of going out and having a third-party company provide the same service that the closing agent was doing previously winds up making the whole thing much more costly.
So we took something that was working well, at least from my perspective as a real estate broker, and we decided to make it not work so well. I like this. How often do you guys meet, the realtors and attorneys? Because I'd like to suggest we not have any more meetings.
They meet constantly, and I have to tell you,
this is coming at us again.
They normally do a great job. I would say the most of the contract is pretty good, and the result
I have to agree.
A long discussion and negotiation and deciding what's best. And I think their intention was in the right place. They didn't like one party paying for services that benefited the other party. They felt like everybody should pay their own way and pay for services that are being provided to them. But in doing so, they've let somebody charge for services to allocate charges to somebody who didn't pick to choose those services, didn't get a chance to shop around. It's interesting. The state, our state Congress, is now working on passing a law which requires a disclosure of those the cost of those services on the closing statement prior to the closing, and a consequence of if you fail to do so, then you won't be able to charge the services, which I think is directly combating this surprise potential charge that some people are getting. Our office has changed the way we now send out our initial communications, and we advise everyone that this is how the contract is, and people can go out and obtain their own services if they'd like. But truthfully, I really preferred it the other way. It made more sense to me.
It was clear. So let me just share a case we had in the old days under the old contract. I represented the seller. The buyer had agreed to pay title services. And I get the closing documents, and the title company had allocated some costs to the seller. And so I reached out to because according to the agreement, the buyer was paying for everything. So I reached out to the title company, and they said it's customary to have these seller charges. And I says, I'm okay with that. Perfectly fine, but you're going to charge the buyer for those because that's what the contract says. So I'm not disputing what you're charging, but you're not going to charge my client. So bottom line, as a real estate broker, my advice to buyers and sellers out there, you need to have this conversation with your agent. If your agent doesn't understand it, you need to encourage them to go to their broker to get the clarity of how he or she wants this to work. Because the way the contract works right now, in my mind, it isn't clear to either side. Michael, would you agree?
I'd agree 100%. And that's just one of the various issues that we wind up running into with the contract. There's also deficiencies in the financing clause, for instance, where people don't realize that they have to get their appraisal within their financing contingency. And if you don't, and the property doesn't appraise out, you may be in a world of hurt, because a bank will give a buyer a approval letter, even a commitment letter that says, we've approved you for financing. And the bank knows they have to do that, or they should know that they have to do that within this financing contingency, which is, of course, the period of time the buyer has to cancel if they don't get their financing together. So the unknowing buyer gets their approval letter, gets their commitment letter, and says, this is awesome. I've got my financing squared away. I don't have anything to worry about. But meanwhile, the appraisal may still be out there. Mm-hmm. And if that appraisal doesn't come in and meet its value, and the financing contingency is already expired, that buyer may not have enough money to wind up purchasing the property. Yep. They have to cover the shortfall. And this was another change that happened 2 or 3 years ago.
And it's when the realtors and the lawyers were all working together again?
Exactly.
Oh, no.
So previously, the appraisal portion of the financing contingency would run all the way up to the closing date. And the joint committee, I think, rightfully got together and said, hey, that's not great. The seller never really knows when they have a sure thing with this buyer, because there's no time frame for when the appraisal was going to be obtained in the old contract. And so that was a change that I think is great that they did. And I think that's should more match the parties' expectations. But a buyer who's unaware of that is going to have a big issue there.
See, this is why it's so very important that a buyer and or a seller really understand the capabilities of their real estate agent. Not all agents understand these things, and you need to make sure that person needs to represent you in this deal and make sure there's no gotchas because you didn't understand part of the clause. And that's their job, in my opinion, to make sure you understand what the contract says that you're signing. And there's more nuances than just this. You need an experienced, well-educated real estate agent or broker representing you that can uncover these and a lot more facts like that. Michael, would you agree?
I'd agree. And these aren't legal requirements for your realtor to provide that level of service. Realtors have relatively low legal standards of the service they have to provide. They have to do some basic contractual things that are provided by statute, not contractual, but statutory obligations. They have to treat you honestly and fairly. They have to disclose anything they know about the property, which is not readily observable and affects the market value. But they don't have to watch your deadlines for you. They don't have to make sure that you're getting everything that you expect to get. Now, a great realtor does that and goes above and beyond what the minimum statutory requirements are. And I think that's why it's even more important. You can't rely upon the law to have a high enough level of competency and support, or required support for an agent. You have to really rely upon the agent themselves to provide that, outside of what their obligations are.
So I think this is the first time I'm actually going to do a commercial on all these podcasts. At Team Rennick, we not only understand these, but we also share this. We try to educate our peers out there. And that's why, many reasons why we do the podcast. Inside the deal, what's going on? Let's pull the covers back. It's imperative. You know, a purchase of real estate many times is one of the largest purchase or a sale that person is going to go through. And it's got to be done the right way. That's why you need to make sure. Again, if you're a buyer or seller, grill your agent or prospective agent. Do they understand? Have them just ask them the question on what are some of the gray areas in the contract that we want to be careful of. And they, again, they're not an attorney, but they can share things about deadlines and things like that. And here, we not only understand it, we're communicating it to the world out there. And Michael, I want to thank you for your help on this.
Of course, of course.
Let me close with an apology for being mean about when real estate agents and attorneys meet together, but I will use that against you sometime down the road.
As you should.
All right, Michael. Thank you. What's your phone number if someone wants to get a hold of you and get more
Sure.
advice and information?
You can always reach me at the office at 941-957-0080.
Michael, thank you.